Hello, everyone. Welcome to the Truth Table, episode 51.75. Just to make it even more difficult to calculate how many shows there were this season. But that's what happens when unplanned circumstances and because shows happen, on the spur of the moment sometimes. And today we've had two shows talk about amalgamation. We went live in Ukraine, and now we have my brilliant friend Chris Weisdorf, who has helped so many and has been a guest on the show so many times. I look forward to our conversation right after this. It is March 29th, near the end of the month, the end of the year, those who follow the 13-month calendar. We will have a late show on the 31st, going through the midnight hour and welcoming a new year and a full moon at the same time. My guest Chris has been on here multiple times and talked to and helped a lot of people understand um, the lawfare being used and the tactics being used by officials. And it hasn't been very fair for us. But if you want the truth and can handle the truth, you're in the right place.
I want the truth! You can't handle the truth!
Welcome, Chris. Thanks for coming back. It's always an honor having you on the show. Thanks for
Thank
coming.
you. Thank you for having me.
So, the Chris Skelly case, that was shocking to me.
You call it Chris Skelly. You're like the judge in the case. You actually misnamed him.
Did I misname him?
Yeah, it's Adam Skelly.
Adam Skelly. Did I
That's
say
how he.
Chris?
Yeah, you said Chris Skelly.
That's your
And
name. That's
and
right.
and then there's his
Adam.
name on his actual given name is William Adamson Skelly, and what he was called in this was actually I'm trying to remember what he was called. I'll just click on it. I keep forgetting what he was called. But this literally is on the decision. I clicked it on it in my Facebook post, the official press release regarding this case. It was 10 days after the fact. We had to. I just had to kind of figure out where we were going to go with this. I knew it would be appealed, but I mean, how do you express what really happened? So it took a little bit of time to express it. I don't like to rush things out, and
Yeah.
it was the actual press release came about a month after the hearing concluded. So I think that's a reasonable amount of time. It's very clear from what I've described what happened. But it literally calls him on the style of the cause. That's the opening page of the decision. He's misnamed. His name is James Adamson Skelly. And I remember Adam sent me this. I just saw he sent me the first page of the decision. I didn't even look at it. He just said, "Who's this James guy? And what are you talking about?" He goes, did you actually read the name on there? I'm like, it's you. He goes, "No, it isn't. Look, it says James." I'm like, "Really?" And then he's sure up. Yeah, it says James. So the judge couldn't get his name right. Yeah.
Haven't cases been thrown out for wrong names and wrong words?
It wouldn't get thrown out. It just
No.
goes to show you the I don't even know what to call it.
Absence of attention.
Sloppy, shoddy,
Yeah.
rushed. it's about
Yeah.
215 paragraphs, and uh, it starts off on that bad note, but also there's so many issues, and the main issues are really about the evidence or lack thereof regarding the case. But if I go to just what it described here, I just say here, um, uh, so his name was wrong on the style of cause. They got Adams' motion decision citation wrong back in 2021 twice. The one that people are really aware of, that hearing back in end of June of 2021. That's the actual hearing that never was. So the judge now should absolutely make mention of that decision, and she tried to, but listed the wrong decision twice, which is unheard of, absolutely unheard of, wouldn't be done at any level of court. She also ignored fundamental questions of law and precedents brought up in written and oral arguments. And in most importantly for us, for the concerned constituents of Canada, which is a not-for-profit, and why we are sponsoring this challenge, is that the application judge did not in any way address public interest standing, which is argued both orally and in writing and backed by an affidavit specifically sworn for that purpose. The judge concluded the application hearing by clearly remarking in open court at the public interest in her challenge, given that the courtroom was packed to the point that it was standing room only, but absolutely no mention of that in her decision whatsoever. What the judge was duty bound to do was to weigh in on public interest standing and say, yep, Adam should get public interest standing, or he shouldn't. Here's why. It's not even mentioned. The words public interest do appear in a decision regarding hearing the different matters brought up in one proceeding, as opposed to kind of bifurcating the proceedings or duplicating the proceedings. And she does mention public interest there, but what happened to public interest standing? Because this is a serious thing, because it allows Adam to step in the foot of the rest of the public, who was not a new opportunity to in any way challenge any of the public health orders, or any of the lockdown order, or anything to do with the Section 22 orders or 24 directions, whatever they were, that were made against many other restaurants and establishments. There were a lot of people who gave money, hoping this would be heard in court. It took 5 years. We were heard, but our evidence wasn't heard.
Yeah.
So I'll start there and have you go on, and I'll get into it.
Yeah, I can't believe she didn't. All the evidence, all the witnesses, the doctor.
Mm-hmm. That's right.
It's just mind-boggling that I thought she was going to be good. The lawyer was good,
and she was good during the hearing.
Yeah,
she was very good. She was she was incredulous at a lot of the city's various submissions made by the city. She was incredulous. She seemed like she wasn't buying any of it. Mm-hmm. And then the same thing with the province, not as much. But with the city, she really slagged the city. And then one would think, I mean, she didn't seem like she gave any type of deference as you would be required to give normally to the medical officer of health, Eileen Davila. The reason why is because Davila just ducked almost every question put to her in her cross-examination. So the judge could have easily said, it's really hard to take an administrative decision maker like the medical officer of health seriously if she wasn't willing to be the three hallmarks of reasonableness by the Supreme Court are transparency, intelligibility, and justification. And if you don't answer any questions and give any kind of real reasoning for what you did back then, years after the fact, when you're free to do so, then the judge automatically is supposed to say, sorry, you're not transparent. You fail on that first leg. But it has to be all three, right? You have to be transparent, intelligible, meaning you have to be able to explain yourself. It has to make sense. And the justification has to be there. None of that happened. So that's what I thought was pretty flagrantly obvious. And then in the actual decision, she named Eileen Davila and or used the MOH abbreviation over 100 times. She used Dr. Hodge, his name, that is the province's expert, lone expert who was proffered for this case, who submitted a mere 24 pages of his report and follow-up. 24 pages, over 500 pages of evidence from us, 24 pages from him. And she mentioned him 16 times. How many times did she mention any of her 6 experts? How many times? The answer is 0. 0. She disappeared them. Never happened before in Canadian history. There's another case I was involved in, the NOW case, National Organized Workers Union, where 127 pages of unchallenged evidence, of unrefuted evidence, and on the other side was the head of the science table at the time. This is 2021, and then it went to appeal in 2022. And he simply said, "I disagree with Dr. Bridle." That's all he said. "I disagree." 9 pages. Dr. Bridle, 127 pages. Head of the science table, 9 pages. And both the Superior Court and 3 judges in the Court of Appeal refused to even look at the evidence. And the reason, but they ducked it legally. They said, "We're not going to look at the evidence because we're not even going to entertain the injunction that was brought, because the court's residual jurisdiction is not to be engaged when there's a labor relations regime which is not being fully engaged." So they used a legal doctrine according to how the Labor Relations Act in Ontario is written, to say, yeah, we understand that you can't seek injunctive relief in front of the arbitrator or in front of the labor board, but we don't care. This is a labor dispute. It's not a dispute that we characterize as something that involves bodily autonomy or informed consent, which it definitely was. But it was total cowardice and everything else you'd expect. So at least it was infuriating, beyond infuriating. And I got this appealed. I got it funded, but they lost. Didn't go to Supreme Court, and 4 judges disappeared. 127 pages of unrefuted expert evidence. So in this case, I told counsel, I said, "Don't let them disappear this evidence." It happened anyway. The reason why the government is dead on this case is because we have the evidence and the government doesn't. And there's no legal doctrine, unlike in that case. There's no legal doctrine that can be used. Any type of procedural, any type of procedural magic, or whatever you want to call it, that they could say, or something jurisdictional, like they said in that case, that they could use to duck the evidence in the Skelly case. And she didn't even try. She didn't say, I can't hear the evidence because it's I don't even know, because in order for the judge to slag the experts, she would have had to be moved by the respondents, the city or the province, to challenge the experts and saying that they were not reliable, they were not credible, they were biased, they were opining outside their field of expertise, that what they said was not really relevant to the proceeding. Now, of course, not a whisper of that. They just ignored. They started first with their disappearance of the evidence, and then the judge, what really surprisingly to me, I thought she heard everything very clearly and would go over everything, doesn't mention any of her experts. She says she admits in a couple of paragraphs, out of the 215 paragraphs, there's expert evidence from us, but she doesn't mention any names. She doesn't say what the nature of that evidence is. She doesn't mention the number of experts, nothing. It's totally disappeared. So that by itself is probably the greatest error made in a courtroom in Canadian history. And I will say that. And if someone says, that's ridiculous, I'll challenge them. I'll say, okay, find me another case in Canadian history, one case where evidence from experts, from multiple experts, was properly put forth. It was properly submitted. It was not challenged.
Yep.
And a judge simply disappeared the evidence. Name one case in Canadian history without excuse. Unlike the NOW cases, it was unprecedented as well. I said, irrespective of them saying that it was an injunction that they couldn't entertain, and there's a three-part test called the tripartite test for injunctions. Is it a serious issue to be tried? Is there irreparable harm? And is there a balance of convenience that favors in granting the injunction as opposed to not granting it? And irreparable harm is satisfied by the evidence. Well, the last two really, but in that case, The irreparable harm was the major one, and I expected there would be, to be a fulsome discussion in Superior Court and the Court of Appeal regarding irreparable harm of the vaccines, and not a whisper about it. They didn't even go into the test. So you can imagine how unnerving that was and unfair and everything else. In this case, there was no excuse given. The judge simply just disappeared the evidence, didn't want to weigh any of it at all. And that's what a judge is supposed to do, is supposed to weigh everything on the preponderance of the evidence. So that's not even just the experts. There's fact witnesses. There are 8 witnesses in all. There's the 6 experts. There's Dr. Trozy as a fact witness, Adam Skelly as a fact witness. Adam Skelly had a Freedom of Information request, which was answered as to hospital capacity back in 2021. It was way below. Everything was a lie. So she should have at least mentioned that. Said, well, I don't want to go into the experts, which would be totally illegal. And said, well, here's evidence from Skelly, but I don't find it credible or whatever. She didn't even do that. She didn't touch any of the evidence. We destroyed them on the evidence in every single point. She drew, she made findings of fact based on the evidence submitted by the government, but directly contradicted by our experts, like directly. She mentions a lot of stuff about transmission. I talked to Dr. Bridle about this, and I said, you submitted like 20 pages on transmission, didn't you? She didn't mention that. She just said they didn't challenge on transmission at all. There's like just 20 pages from Dr. Bridle which challenge on transmission. So it's silly. It's not. And you look at the smile on my face. You really can't take this seriously and can't let it get to you. It is beyond infuriating and unnerving. But if you take it too seriously, you'll just get demoralized. And I've told people in the press release, don't get demoralized.
Yeah.
Because if you're like, well, we expected to win, we did expect to win, but we also always from day one, I literally the very first time I spoke to Adam, I said, Adam, know that whatever happens will go to appeal. So it doesn't matter what we lose, what happens to the province, the city, what happens to us. It doesn't matter. It's going to go to the Court of Appeal. So I said, prepare for that. Like, we're going to have the money for that. We're going to have to make submissions. Hopefully we'll make them on as a respondent, meaning that we won and the government's appealing. In this case, we didn't win. But either way, because of the nature of the case and how the judge disposed of this case in Superior Court, the evidence is front and center. Ordinarily, it wouldn't be. If we won and Adam, was found to his convictions were essentially overturned because he was found to be acting in a way that was consistent with the charter, the government breached his charter rights, or even just one right. And the judge simply said, I find one of his charter rights is breached. I find the government didn't justify anything under Section 1. The expert evidence is very clear, and there's some balance of probabilities he wins. She could have written a very short decision and given Adam the win and kind of buried it. And then the government would have challenged, and then maybe on appeal, the evidence definitely would not be front and center in front of the judges. In this case, it has to be, because it is the very crux of the appeal. It is the center of the appeal. Everything revolves around the evidence, which has been disappeared. So anyway, I think that's the real point.
Well, either she was threatened from above, compromised somehow because of the impact of a win would set precedent for all the other examples that happened over the years, all the other breaches of trust. So maybe that's what did that, because you had such a strong foundation to show her. It was irrefutable to me. Like, you had everything to prove your case. And even as she was speaking, as you said, in court, she seemed, balanced and, correcting the prosecutors or the Crown.
The government, it's like the city's council and the provincial council, the attorney general's council. Yeah, that's absolutely what happened. And I can tell you, I think I have to make this clear. I think this is an important point to make about courts and judges. Is they're human like all of us, right? So
Yeah.
when they're there in the court, judges they all have tells, just like people at a poker table. They all have tells, and generally, I would say for the vast majority, I haven't watched too many hearings, but I watched my fair share, and I can tell you, judges would make very terrible poker players because they have massive tells, a lot of stuff with voice intonation and with body language that indicate what they're thinking, what they're favoring, and how they're reacting to the various arguments made by both parties, by both sides. And in this case, the judge, I thought, and as I said, I've seen this a number of times. I thought the judge couldn't possibly be more receptive or favorable to our counsel, and really, she was asking legitimate questions of the city solicitors council and the attorney general's council, but she was really incredulous about what the city was saying. Wasn't really buying anything what they were saying,
Yeah.
and with the province wasn't buying a whole lot, but maybe a little bit. And then what did she do in her decision? She gave the most amount of deference to the city.
Yeah.
You could read the decision. The
Complete
MOH
opposite.
mentioned over 100 times, right? With Davila's name or MOH's name mentioned over 100 times, 0 times for us. So she relied very heavily on the medical officer of health in the case, even though she wasn't buying anything in the actual hearing. So that I can tell you, I've never seen this.
Yeah.
And it's not,
Crazy.
and you think, oh, a judge can put on an act for 3 days? A Hollywood actor couldn't put on an act for 3 days, which would be that convincing. So no, I don't think so. I think she was ready to give Adam this entire case. I thought that. I thought she said she wouldn't be able to have the decision ready for his sentencing hearing on March 18th. So she asked, she said, can you, Mr. Attorney General, or representative for the Attorney General, can you talk to the Crown Prosecutor and just say that I'm going to render my decision? It's not going to be ready by the 18th. Like, you need to give me extra time. Can you give me extra time, please? And when they went to recess, when we reconvened, oh, Your Honor, no problem. I mean, take as much time as you need. But he was like, don't take 6 months, but take a couple of months. In other words, I was asked many times, when do you think decision will be in? And I said, well, because of Adam's sentencing hearing, it can't be slow rolled, right? There are other cases that have taken, like the Hillier case took 6 months. The CSAS case took like nearly 2 years. The judge in that case slow rolled it by nearly 2 years and handed him a big loss. So I said the likelihood of that happening in this case is pretty much zero, because the judge is not going to leave the prosecutor hanging for 2 months, for more than a couple of months, I don't think. But if she really puts her time and effort into this case, gives us, instead of a 50 paragraph decision, a 350 paragraph decision, going over all the evidence and doing all the stuff that we want, which would make it impervious upon appeal and allow the Court of Appeal to focus on the evidence, and to allow everyone else who's watching to focus on this and give us another big win on appeal, then
Mm.
she's going to need hopefully a couple of months. And that means decision would be in at the end of April, beginning of May. So, or sorry, is that right? 2 months. It would be March, the end of March. Sorry, it would be the end of May. Right. But it was the end of March. It would be 2 months it would be about the end of May, sometime, or mid-May, or whatever it was. So, or yeah, let's say the end of May. So that didn't happen. She got the decision rendered on March 17th. And that
Yeah, it seems to
decision,
me if she would have
yeah,
went along with the right choice, the whole system might have collapsed. The
yeah.
whole the
Well, it would have,
integrity,
yeah.
but I think she didn't help it either by doing what she did. The
Now it's
integrity.
gonna get 10 times more attention. It has to, because what they did was they didn't even post a decision on Canley. Every decision is posted on Canley that has any type of relevance. And
Mm.
if it individual people can, I don't have the link on me, I can get it for you, but there's a link that you could use to ask Canley to publish a case. So the link is on my Facebook post, it's on my X post, It's on our website, the CC Can website. It's on our GiveSendGo. Everything is around, and you can get that file and you can download it, and then you can submit it to Canley and say, if a bunch of people do that, like let's say 50 people do that, they're going to publish it. And it's a garbage decision. As I said, it's beyond sloppy. It's not something you'd expect from a justice of the peace, newly like minted, newly sworn justice of the peace, who doesn't even have to have legal training before they become one. So they go into training first. They wear a white sash and they go into training. Eventually, they get a green sash, right? If you're a judge, you get a red. That's how it works in the provincial in courts in Ontario. And if, when you're a judge of any kind, you get a red sash. So that's pretty much like the lowest in the totem pole. And there are a lot of justice of the peaces, and a lot of them are very good officials. But the bottom line is, you wouldn't expect something from one of them like this, let alone from a justice who was sitting on the high court bench for several years, since 2019. You would not expect something like this. It does not have the attention it deserved. There's some insufficiency of reasons. Certainly not weighing the evidence. Like, the judge should have simply said, here's the evidence and I'm weighing it. And here's why I'm downweighting these 6 experts, because she clearly downweighted them by not mentioning them. That's implied. She downweighted them. They're not even worth mentioning. That's the implication. And you would need some kind of legal basis on which to downweight them. And in fact, our counsel, Ian Perry, that's Adam's counsel, his lawyer, he impugned the only witness brought, which was Dr. Hodge for the government, for the Ontario, the Attorney General, and she said, he said that that this expert should be downweighted because, number one, he was paid over $500,000 for various testimonies he gave. He's a hired gun. Number two, so he was, his reliability was, in question. And the second thing is that that he was under a policy from the College of Physicians and Surgeons of Ontario regarding being unable to challenge the narrative regarding lockdowns and COVID. And Ian Perry, counsel for Adam Skelly, said there's no evidence that this policy was ever rescinded. So, and because, he didn't ask him this in a cross-examination, therefore, I'm not going to consider downweighting him. Okay, fine. But then why did you downweight our experts? It makes no sense. It's ridiculous. Yeah.
It is ridiculous, and I think she really had a lot on her plate, because the foundation of the Law Society and the power structure of the city and the counselors, and they love their power, was all on the line. So I think that might have weighed into what she did, but ignoring actual evidence is, to me, borderline criminality.
It's you are not following centuries of British common law doctrine, tradition, and practice. If you go back several centuries, it's not like the courts, like we had computers, right? We had laptops, and that you could easily look this stuff up and then cite it in the case. No, we didn't have that. The common law, there were certain cases that they were aware of, but it's not like today where they would mention like 20 cases in some decision or more. Maybe they could mention 50 cases. They could mention more. They would just go over the evidence, like in a civil proceeding of what you have two parties and there's some sort of civil dispute as opposed to criminal. And they would just go over the evidence and dispute and decide for one party over the other based on the scales of justice. Who wins? Who wins the preponderance of evidence? Who tips the scales? That standard has been in place for centuries. So you go back, a couple of centuries to the 1800s, and you look at how courts decided stuff back then. It was really on the preponderance of evidence. There was a legal basis, but it was really on the preponderance of evidence. And you look at cases today, how they're decided. It's on the preponderance of evidence. It's on the balance of probabilities. 50% plus one. Who tips the scales? Well, the scales are always completely lopsided and tipped vertically in our case. It weighs very heavily in Adam's favor because we have the expert evidence and the government
Yep.
doesn't. The government has one expert, we have six. If you look at the Taylor case, which was the only case to make to the Supreme Court in Canada, COVID related, it was
Hmm.
decided last month. It was decided very recently. And the government had four experts, and the appellant had zero experts. And the Supreme Court ruled 5-4 in favor of the government. So very narrowly in favor of the government. What if she had the four experts and the government had zero experts? Right? Like in this
Mm.
case, we have six experts. The government has one. Davila ducked most of her questions, so she could be, there could be some kind of administrative deference, but at the end of the day, she
Hmm.
can't be taken seriously because she ducked most
Yep.
of the questions.
Yep.
So they don't have a leg to stand on. With respect to evidence, they don't have a leg to stand on. They don't.
Do you think this is evidence of a coup?
You mean that the courts are being taken over?
Everything. The police,
Yeah,
RCMP,
yeah.
politicians.
Well, we know from the Helen Bruce case that clearly you're not allowed to enforce the law if the government doesn't want you to. You're
Yeah.
not allowed to. So that by itself it has a chilling effect on all law enforcement people, because if they want to enforce the law, they're not allowed to. Because if they do, they'll be disciplined severely. Like there was one police officer, they found his name eventually. He was not public about it, but he gave, maybe it was $50 to the convoy, and that guy they tore a strip off of him for the $50. So it's very clear, if you're the government, you have all the power. Your officials have to obey their employer, and everyone has to obey the government. And then you have the government protection racket, which are the regulated professions, and you
Yeah.
have, so the government creates this protection racket by creating a bunch of monopolies by law.
Yep.
And if you're in the regulated profession and you do something the government doesn't like, they will pull your license. They'll destroy you, like they did to Dr. Trozy. Look what they did to Dr. Hoff. The only reason why he survived is they dragged him through the mud for 2.5 years, then dropped the proceeding because he had 8 experts. They didn't want to hear the 8 experts because they would have shown
God.
fraud. They would have
Oh,
literally shown medical fraud and scientific fraud. Now, in Adam's case, because the evidence is so old, we couldn't show the fraud. It would have been very nice to, but we have to show the evidence as it existed back in April, May of 2021
yeah.
and earlier, but not what we know in 2025 or 2026, because hindsight is 2020. You can't do that. There should be an inquiry, and there should be a full-blown Nuremberg-style military tribunal. In order to get there, we need to win civilly. And
Yes.
Adam's case is the best case now, I would say, on the planet, that has a chance of forcing judges from now the highest court, other than the Supreme Court of Canada, the courts of appeal are the highest courts in Canada and the US. This would be the
Hmm.
Ontario Court of Appeal. Three
Yeah.
judges, maybe five judges, would weigh in and say, here I am looking at the evidence that the Superior Court judge, application judge, refused to weigh, and then she just didn't address it at all. So we're going to do that, and they're empowered to do that. They're empowered to do that. In other
Yeah.
provinces, maybe not. In other provinces, they may send it back to Superior Court. In Ontario, they're empowered to do that.
And
So,
you're
but
right.
I'm not. Yeah.
You're right. We don't want to learn helplessness, even though
Mm.
I'm automatically feeling that. We certainly don't want to encourage that,
Mhm.
you know, because there are good people out there, and you'll never guess who's watching us right now. Canada's Joan of Arc, Kelly, Kellyanne.
Oh, okay.
she
Nice.
is
Yeah.
watching us. Yeah.
Okay.
And
Well,
I appreciate
yeah.
her and all of you. I appreciate all the people that I've met since 2020, because I've met probably the most beautiful people in the last 5 years, 6 years, than my whole life. And that's the truth. It's like we were all brought together like a magnet, uh, realizing that we're in a bad situation and we really need to, uh, we really need to find each other and do what we're meant to be, become who we're meant to be, as you did. And with Colin McDonald, I mean, that was a scary situation for him. just for speaking, just for talking.
Yep.
He was facing a lot of time. They like to threaten us with ridiculous penalties for just living day to day, for speaking to a crowd. I'm surprised they haven't come after you just for helping us.
I did back in 2021. I believe it was, or actually, what year was it? No, it was 2022. I did get a threat letter from the Law Society because Rebel News and the Life site, they both conducted interviews with me back then in 2021. Sorry, it was so the interviews were in 2021. One
Yep.
was in May. The Life site, that was the Rebel News, was in May. The Life site one was in, like, I believe it was September. So eventually someone reported me from a lawyer from Windsor. And then eventually the next year in 2022, I got a cease and desist threat letter from the Law Society saying, please refrain from presenting yourself as a legal professional and providing legal advice. So we're going to prosecute you. And I didn't even respond because I knew for a fact I never did. And that the reason why this happened was because Rebel News presented me as a lawyer, and so did LifeSite.
Oh,
I wasn't even aware of it. And not only that, someone else presented me as a lawyer in Windsor when I went to speak in Windsor. And it
wow.
was just so, I told everyone, made it very clear. I said, I have zero legal training.
You
I didn't
always
go to
have.
law school,
You
and I've always said it. So,
always.
I always say I'm not a lawyer. I play one on TV. Like, I've always said it. And despite me winning, like me being the only victor in a
Just for your
Quarantine Act
input, yeah.
appeal in all of Canada, I'm the only person who's won a Quarantine Act appeal, literally out of over 40 million people. And that's, like, I'm not bragging about that. That's actually scary. How is it that I won something like that and all these skilled lawyers did not? It's not good. And I did it because I just did 10 times more work than anyone would normally do. And if a lawyer took on a case like that, it would cost between $30,000 and $50,000 for a $5,000 ticket. So the math is upside down.
It's
So
crazy.
yeah, but with this, but just addressing this threat letter, I if they sent me another communication and they tried to, or let's say they outright charged me, I would have said, I've always provided a disclaimer. As for LifeSite and Rebel, I'm I'm not in control of what they put. If they present me as a lawyer, even though I've told them I'm not, um, then it's not my problem. And as for other people, if they present me as some kind of legal professional when I'm not, that's not my problem. So I would have said I made every effort. Due diligence is what it's called, due diligence defense, saying that I've done all this, I can prove it. Then they wouldn't even get to court. But the point is that they still tried, and outside of that, I've been okay. Financially, I'm not doing well because of I stuck my neck out so many times for people and help people. So I'm not doing well financially, but my health is good, and I have a mother who's understandably she's somewhat aged, and she's okay, and I'm doing all right, but other people maybe not so all right. So and if they want to come after me, what are they going to do now? The work is done, right? Even on the appeal, like, the work is done, right? It's very clear what needs to be done now. I mean, the vast majority of effort, almost all of it, was in the original case in the court of first instance. That's the whole thing. The court of first instance is where you have to do all the work and put all the evidence there, because you can't get a second kick at the can. You can't go, you know what? I'll see it through, and then I'll bring the expert evidence. I've told a bunch of people, no, you cannot do that. You don't get a second kick at the can. So now on appeal, the appeal is a fraction of the cost of anything in Superior Court. It's cost over $600,000 to have this heard in Superior Court now, and there's tens of thousands of dollars owing to in legal bills in this case. So we have not satisfied the legal bills as a sponsor. We have not. And Adam doesn't have the money, so we have to satisfy that and satisfy the appeal, which won't cost very much compared to the actual hearing of the Superior Court application. Yeah.
I'm surprised you got that letter because anyone could read legal documents, read legal books, and case law, and be informed to give information to others. I could read a medical book and acquire knowledge from that book and be able to share. I don't have to be a doctor to have that knowledge and share it. So you getting a threat, that is quite that's scary. That's really scary because you've always been very clear. I'm not a lawyer. I'm, I'm not giving legal advice, but
Just give me 1 second. I just want to
yeah,
close my door. Just give me one
yeah,
second. Hold on.
sure. So Kelly is in the audience. Kelly, how you doing? Love you, my sister. She is the Joan of Arc of Canada. All she needs is a horse and a steel-plated vest. I think the judge in this case should be thrown off the bench. Honestly, any judge that does these sorts of things are, and just like the case with the Emergencies Act going to the court, Supreme Court, they're all appointed by these politicians. So you know darn well we're not going to get a fair a hearing with the Emergencies Act.
Oh, hold on. So I'm back. I want to weigh in there. I don't
Sure.
believe. So this whole Emergencies Act case has turned into a real like lightning rod, and so uh, and Adam's case hopefully will as well.
Mm,
But with respect to the Emergencies Act, um, the government has lost twice already, very badly.
yeah.
The government lost originally in front of. They're all liberal appointees, and they're look at the Now case. There were two conservative appointees, still didn't want to hear any evidence. Okay, so it doesn't matter who you're talking about. But I will
Yeah.
say that in the federal court, that lone judge, Mosley, liberal appointee, he went and decided 100% against the government. Okay, like really bad loss in Superior Court. And they appealed it, or federal court. They appealed it to the Federal Court of Appeal. There were three judges who heard that appeal, and they 100% upheld that decision. No, there was no wiggle room at all. No one. Usually, when something goes to the Supreme Court in a case like that, it's because there's a dissent. One of the three judges says, um, I disagree with the majority for these reasons, and they come
Mm,
up with the different reasons, and that didn't happen. And so if they want to get it to the Supreme Court, they're going to have to demonstrate that it's worth hearing it on a substantial basis, and the Supreme Court could possibly hear it, and
mm.
then hear it with seven judges instead of nine, and have Chief Justice Wagner recuse himself for making comments, and he would have to recuse himself. For that reason, I don't think I've never no as I don't know that I'm just going to make a blanket statement, and I don't know if it's true or not. I'm pretty sure, but I don't think a chief justice in Canada has ever recused themselves in a case ever. I don't think it's ever happened. So if the chief justice had to do it here, everyone knows this. Everyone knows what he said. He didn't just make some happen to go off one day in February of 2022 and said he was really upset at what was going on in Ottawa. Nope, he doubled down. He went off another time. So he absolutely should not be anywhere near this case. And so that would mean you have to have an odd number. So there's nine justices. You'd have to have seven. So he could recuse himself, but the optics of that are so damning
Mm.
that's why the Supreme Court could easily just say, we're not going to hear this case. So I don't think they'll hear the case. If they do hear the case, what will they find? It'll be unanimous, saying that the Federal Court of Appeal their decision cannot be overturned. So, and how do I know that? Because not just their reasoning, but look at this, what the CBC and other news outlets have said. They've all said that while we may have not agreed with their methods, that they were entitled to do what they did. There was no violence there. They actually say that now, but they didn't say that back then. There was a lot of lies back then. J6, there was stuff done, but there were 500 agents from the U.S. there. Everyone knows that. I don't want to go into it. But with respect to Ottawa, there were a lot of attempts to infiltrate, and they failed. And so, that's what happened. So, yeah. Mm-hmm.
I'm not sure what you mean, Jeff. Could you review that issue that Chris is facing? I'm not sure what you mean by that. What issue? You'd have to be more clear on that. Jeff, you can also join us if you want to ask him a question.
Well, I see one comment about judiciary is incompetent in general. I would not agree with that. I don't think the judiciary is incompetent. I just think that the judiciary is not allowed to decide freely,
Mm,
and that's a very serious statement to make. Adam
I
can't say it
agree.
publicly. Our counsel definitely can't say that. I can say it. I would say
Yep.
that they're not free to decide. If they were free to decide, you'd actually have the judges discuss this stuff and say, there's a lot of evidence here. I'm going to go into some of it, but I'm not sure I can hear it. The judges would be very open about it, saying that there's a lot of evidence here. It's uncontested, really, and we should look at it. And the judges are not doing that. There are numerous cases where they won't look at the evidence, or they say, in the Trinity Bible Chapel case, which wasn't a good tabling of evidence, she just said, "Who am I supposed to believe?" You're supposed to judge it on the preponderance of evidence, as I said. So
Absolutely.
I wouldn't say that they're incompetent. Just like if you have people in the legal profession who were they have decades of legal experience. Everyone blows cases, right? Everyone makes mistakes. Michael Jordan in his prime, basketball player, would miss a dunk from time to time, if you can believe it. So it happens, right? And you'll
Yep.
have,
Yep.
but at the same time, if it keeps on happening in certain types of cases, and it's happened now for the second time with respect to evidence which was unrefuted, and they're just not hearing it,
Yeah.
then that's very
Bad.
serious, and that
Oh
indicates
God, yeah.
something that the institution itself could be
Self.
compromised. And the only way
Yeah.
to
Yep.
uncompromise it is to have a higher court overturn it. So there is hope that the federal court, Ontario Court of Appeal overturns the decision in Superior Court, and that it stays there. And I don't think it'll go to the Supreme Court after that, but you never know. This is the type of case that could
Yeah.
possibly go to the Supreme Court. We'll need more money for that. As I said, we're in the
Yeah.
hole right now for tens of thousands of dollars. We still owe that, plus then the cost of the appeal, and then how much would it cost to go to Supreme Court? Not that much, but still, we don't have it.
Well,
A fraction of what we owned. Yeah.
I will link the Give Send Go. It's a Give Send Go, right?
It's a Give Send Go, as well as our website, our newly done website it's nearly 3.5 years after we got an initial website, which is not a good
I
site.
see it.
We have a newly done site. Yeah.
Legal challenge. Okay. Oh, that wasn't it. Okay,
I'm
I'm
sorry,
just gonna.
my mother is not well. Hold, give me a.
It's
It
okay,
is what it
brother.
is. She's not well. Sorry.
It's okay. I'm just looking for. Give Send Go. Okay, I found it. I want to add this to the description. That way, anyone at any time can um, join or help Adam, because this is a big deal. It's a big case. It might not. Let me see here if I can. You can help Adam here. Okay. All right. Updated. I don't know if that's going to work. And I see Chris has gone. He will return. I know my first guest from Arius, episode 1, second season, has a question for you, Chris. His name is Jeff. He was on the first episode of
Hello, Chris.
season 2. Hello, my friend. Welcome. Yeah, you asked about the case, the
Well, I
issue
was
that.
wondering. Chris, what you're facing. I joined late. I saw that this was going on, and of course, Chris, we met. You may not recall, but we met at Cullen's hearing.
Yeah.
Um, and
Is he
connected.
here? Is Jeffrey?
Yeah.
Yes.
Can you see
She
him?
says could no. I just see the background with the plants and all that. I don't says can you review the issue that Chris is facing? So I just
Okay,
want to
let's
hear
see here.
what that I want to hear what that is.
Yeah. So I believe you were talking at the time about some sort of determination or letter that you had received or something about practicing law, and I was wondering if you could
I don't know what's going
frame
on. I
that
don't see. I
because
mean, I see his name. I see everything here,
I
but
see him. You can't.
I don't
Can you hear
see
him?
I don't hear anything. I don't see a face.
So he doesn't hear you or see you. Well, that's very strange.
I don't know what's going on.
I hear and see him.
Oh,
well,
you want me to reconnect?
Yeah, try leaving and coming back. That
Okay,
might fix
okay.
it. That might fix it. Yeah, he can't see your pretty face.
I can certainly hear him and see him. So
Yeah, I can see. It's got to be him. It's his
yeah.
fault.
Well, I'm just wearing a t-shirt. I'm not wearing a suit like you, Paul. I sort
Oh,
of you caught me late
yeah.
on a Sunday night, but
It just goes to
it's
show.
good to
I'll
talk to
take
you
that to
again.
anybody.
Geez, I can't believe how many episodes you've done since I convinced you to do that first one.
I
What
know.
is this, number 51?
I no, it's like 51.75. I have a 51.5. Like I don't even really know.
What are the
You need,
points for? Was
that's because
51 with Chris as well?
I have another show booked tomorrow, and two shows happened today that weren't supposed to happen. This one and live from Ukraine. So when a
No?
show is just thrown in between two shows booked, I give them a zero point 0.5, and in this case, 0.75. Means I did
Yeah.
three shows today. But I'm glad you're back on because I'm finishing season 2, and you started this season with me on the
Okay.
first show. So
There's been a
yeah,
lot of issues that we could have talked about, but I've been trying to keep my head down
yeah, and
and
you've been traveling.
laser focused on things as much as I can to make sure that I'm in
Mhm.
good shape for the things that come in the new year. But certainly one of those things, the amalgamation story came and went. I thought there was a pretty funny comic about it, but it's not a laughing issue.
No,
Overall, we do need reform in the Niagara region, and yet we also need democratic participation. So there's
yeah,
good arguments on both sides around
yeah.
that, and something to be
That was
considered.
today's show, the first show about the amalgamation.
Oh yeah, who was on for
Yep.
that?
Mina Antis, and I also got Cheryl Rowe was also with us.
Okay,
I hear you and see you.
Yay!
Chris,
Yeah.
good to see you again.
Your
I don't.
your voice is good, but for me your screen is distorted. But I can kind of see your face. But I can hear you.
Okay.
Yeah.
Hmm.
Well, I am kind of Sunday evening esque. Just sort of caught me off the fly, but we met once before, Chris, and it was at Cullen's trial. But in
Okay.
any event, I was asking in terms of that question was if you could restate what you were facing from the courts. It sounded like you received a letter and that there was some concern about you potentially practicing law. I didn't
Oh,
catch that part of the issue, so I was wondering if you could just cover what it was that you're facing on that front.
the Rebel
The
News thing.
the main issue they had was that they thought I was speaking about legal issues, and that not just speaking about legal issues, but presenting myself as a legal professional. I did no such thing. But the way that the Rebel News portrayed me and LifeSite portrayed me and someone else in the Windsor area portrayed me in a bunch of flyers before I spoke there, um, indicated that I was a legal professional. I told all of them on multiple occasions that I was absolutely not a legal professional. And I always say I'm not a lawyer. I play one on TV. So they go, but you went to law school. I'm like, no. But you were a paralegal. No. But you went to paralegal school. No. I didn't. And then this is what the judge said in the Fernando appeal, the Quarantine Act appeal. Same thing.
Oh, so you know how to read.
Well, yeah, but he was incredulous at the submissions that I made. He said, "Well, so you went over the law school and you were a lawyer, and then no, but paralegal, but you went to paralegal, no, but then you had a lawyer help you, no, but you had a paralegal help you, no." He's like, "Okay, then." He just couldn't believe that I put it together. So, yeah.
I mean, I've seen your submissions before. I've heard your arguments before. I've heard you discuss before. I can see the confusion, but you are what the United Nations refers to as a human rights defender, a person who takes an interest in the law and fights for the rights of all Canadians. We're all citizens of the world, and you don't claim to be a lawyer. In fact, you probably make arguments that lawyers would feel duty bound to avoid.
Well, the arguments that I made in both the Fernando appeal and the McDonald double appeal were arguments that are made by some corporate lawyers, but they're not made in any type of case that involves one's rights, civil rights or constitutional rights or quasi-constitutional rights. They're not made. The doctrine of conflict of law is really never, very rarely invoked in non-high paying cases, right? You have a lot of billable hours with corporate counsel, and they're challenging, like the U.S. Steel case and things like that. They're challenging the interpretation of the statute and the ministerial powers and things like that. They have high-powered counsel. They have 10 lawyers weighing in, and then you have the 2 or 3 who actually go and litigate the case. There's a lot of money spent, but what I did was I know those cases very well, and I said you have to really look at how the law is written. You got to interpret it properly, and then you have to apply this doctrine of conflict of law. And they kept bringing up stuff like the Spencer decision from federal court, Chief Justice of federal court. And I said it's not applicable. I'm not arguing any of that stuff. I'm not arguing the charter. I'm arguing the Bill of Rights, but I'm arguing primarily the Section 14 of the Quarantine Act. So that, and the judge really wanted to hear about that. He didn't want to hear much about the Bill of Rights because I wasn't particularly interested in that either, even though substantial submissions were made, because the most we would have gotten in terms of the Bill of Rights arguments where it was a new trial. What we got was by arguing Section 14 of the Quarantine Act was the actual conviction was overturned because the legal basis could not be sustained. And that's what happens when you make advanced arguments that no one else is really willing to make. And if you had really high-powered counsel on something like this case, someone got really interested and just was very disturbed at what was going on with the Quarantine Act tickets, then you would have had the result that I got from a very good lawyer. That didn't happen. No one took interest, and I was the only one.
So this is kind of the plight of what human rights defenders face: is they seek, the just outcome, but they are denied access quite often via this kind of economic barrier, right? This idea that whether it's our constitutional rights or the policies that are supposed to flow from our constitutional rights in order to make sure that we're treated fairly can be monetized and denied by the price of a legal defense. I don't know if we've lost Chris here.
I see you, sort of. I
Okay.
don't know. It says connection. I see you and hear you. You didn't really cut out for me. I just didn't see your face there, and I saw about the connection lost, reconnecting. I'll just wait a little bit, but I seemingly hear you and see you. So I don't know if I missed anything. Maybe I have. I'm not sure.
So I was talking about how human rights defenders are often find themselves in this situation where they're attempting.
Can you hear me?
I can hear you.
I'm going to reconnect.
You have to reconnect because you're frozen.
Well, Hold on.
You are
Should I reconnect
frozen.
now, or is it okay?
Yep.
Is it
Yeah. No, reconnect.
We can hear your voice, but your face is
okay? I'll
frozen.
reconnect.
Your screen
I'll
is frozen. Yeah.
reconnect. I'll reconnect.
Okay. Yeah. Yeah, you nailed it. What the UN describes him, he is definitely one of those. Um, I
Well, the,
think I love
the
the fact that you're right that he can say things that lawyers might not say.
well, there is an obligation under their code of conduct, and
Yeah.
most of the bar associations across Canada, or law societies as they may be called, um, to only speak positively of their profession. So to
Mhm.
call out where there may be barriers to um, good governance as a result of this barrier that people face related to cost,
Mhm.
it is really a significant one. It's partially um, dealt with pro bono work of lawyers, but what we don't see is kind of this ready access, especially in times like we faced through the pandemic, this ready access to the law as
Mhm.
a resolution when good policy or human rights are denied. Um, this instance, or this topic that Chris was talking about just now, as it relates to the conflict of laws. You know, Elon Musk made reference to that recently in one of his cases where he was being pursued for not hiring immigrants, and yet the laws that govern spaceflight mean that you have to have only citizens working for your organization in most areas that relate to spaceflight or defense. So, it was this conflict of law where he was being pursued. Um, and so, these are the types of things. Chris was very right to point out that, this simply is not in the hands of individuals who are seeking their rights. And whether it's the pandemic cases, where it's the cases where people are being denied access to medical treatments or drugs that may be used off label in other countries, it's the same sort of thing, right? There's this overwhelming power that is used, and the court system is both obstructionist in its processes and the weight of those processes, but also the need for high priced legal representation.
Yeah, I added the Get Set Go in the comments. If anybody would like to go there and check it out, it's there for you. He's got 45,000 out of 100. So yeah, definitely thousands left to go to finance. It's a shame that we have to. The government will use our tax money to fight against us, but we have to come up with our own money to defend ourselves. It's just a scam. If I feel like we're dealing with criminals here, like a
Certain,
coup d'état happened in Canada, and while we were sleeping in our comfortable in our comfort of democracy.
I don't know if it was just youthfulness, but it does seem like there was a time where we felt like we could really trust our judiciary
Yeah, yeah.
um, to speak on behalf of what was right for the people, and not necessarily, you know, there's this feeling that if it's not the judiciary, it certainly might be the crown, or it might be the government agencies that are weighing heavy on their power these days. Um, uh, and the oppressiveness of the court system itself. So, Chris, you're back. We can
Yes,
see
and
you.
you're moving. Chris, do you think there's any way for Canadians to get back their country? Like, is there any legal way of doing it? Do you think?
This is it.
Uh
We're
oh.
it. Doing
You
it.
froze
We
again.
call out the lies. If you can
Oh, we
prove the lies, can you hear me? Can you hear me?
I can
Okay.
hear you, but you're frozen.
oh, now you've dropped.
Yeah, no, he's right. He's right. we, this is a part of doing it is by exposure.
Yeah. Yeah, hopefully you can hear me. At least you can hear
Yep.
me, hopefully.
You're
So,
good.
so I would say that in order, like the Great Reset, I'll go back to that, is all about you will not own anything, be happy. You will not vote and be happy, and um, uh, you will not go to court and be happy. And how they do that is they relieve you of your private property ownership because it's we know it's
It's
just not fair to
cumbersome.
own private. It's too expensive and it's too unwieldy and it's too
It's
difficult to manage.
cumbersome.
It's
Yes.
cumbersome. And then why bother voting? It's so
Yeah.
corrupt anyway. Why bother? And then why bother going to court? Don't worry, we'll have these nice little tribunals for you where you don't need a lawyer, just so that the government can stack everything against
Yes.
you.
With
So
free.
the
Yeah. With
so the, the
free.
whole thing the whole
Go
thing is
ahead.
to engage the system to and especially if with an evidentiary matter like this, to ram the evidence down their throats until they throw up and then ram it down their throats again and keep doing it so they can't disappear it. This is when you're dealing with it's the same kind of very unfortunately, and this is where what the courts have become. If the courts properly weighed the evidence, then you'd have a nice civil proceeding. Now here I am slagging the courts, not too heavily, but nevertheless, I'm doing it and other people are doing it. Instead of going, well, they gave Adam Skelly a fair hearing. They didn't, and if the evidence wasn't properly weighed. So you are literally, it's like when you're facing a narcissistic sociopath who keeps
Uh,
lying. That's what we're dealing with. So we
yes.
have to keep calling them out in as public a manner as possible and not let them silence us or disappear us. Keep doing it
Yeah.
and see what happens. I mean, maybe the Court of Appeals somehow refuses to acknowledge that there's any evidence to the contrary regarding the narrative which six experts exists. Maybe then it goes to the Supreme Court. Maybe then the entire Supreme Court ignores it. I don't think any of that will happen at all. But I've always thought, I said this back in 2021, that I don't think I said I just don't think that any Superior Court justice is going to give us a win. I said that back then, and frankly, people were not happy to hear that. And I said, it is what it is. Like, it will end up in appeal regardless of outcome. It doesn't matter what happens. We're going to end up in the Court of Appeal. So, and when years passed, and then when we actually had the hearing, I thought it went extremely well. Couldn't have gone better. So I really thought we had the case in the bag. So
Mhm.
now I'm not going to go in any of that. I'm just going to say that it'll go to the Court of Appeal. So it hasn't been appealed yet. It will be appealed. It will be heard. It doesn't take that long to hear it, assuming that everything goes as scheduled, without any kind of delays. It could be heard as early as like the end of October. Okay,
And so,
something like that. Yeah, November, let's say. Yeah.
so the issue of law that you're bringing forward for this appeal again, Chris, and I'm sure
I
you've
can't.
covered it.
I can't tell you what's going to be brought for the notice of it. I cannot, and that would be. Hopefully, you can hear me. Can you hear
Yes,
me?
we
Let
can.
me know when you can, and then I'll start speaking. Okay, so
We can.
I can't tell you what's going to be in the appeal. What I'm telling you is I made an official press release saying what the largest concerns are. There are other, we don't know. I can't tell our counsel, was Adam's counsel. I can't tell him what to put in the notice of appeal. I wouldn't dream of it.
Mhm.
I could say these are the major issues and that the evidence is substantial. So there are numerous things in terms of legal strategy, and I can't tell you. I can be very vocal about what went wrong in this case, but Adam hasn't
Mhm.
commented, counsel hasn't commented, and they're not going to. I can comment because we're the interest organization, and not for profit, which is sponsoring his case in the public interest. Should be heard because there are other people's, and that's why it should be heard. It's not just Adam. Adam is almost irrelevant at this point. This is years later. Even the criminal stuff, if it goes away, I mean, he was convicted. He's supposed to be sentenced on the 18th. Didn't happen. It's adjourned. But at the end of the day, it's really not about him. It's about all the other people who businesses. There's so many.
Well, since he seems to have dropped off here, I don't know. Is he still there for you, Paul? Oh,
I'm It
You're
just
back.
says waiting for. Okay, I don't know what's. And I should have warned you. My connection has been really bad since the end of December. I've been waiting to get it replaced. It's on copper twisted pair. It should be on fiber, and just months have gone by, and I still haven't had the fiber put in, even though it is put in for other stuff, but not for my internet. It's ridiculous. So I should just tell you that's why this is going on.
Well, that's too bad. You're back.
Back to the appeal. I can't tell you what's going to necessarily be appealed. I can tell you
Okay.
the
What
issues
are
that
the
I've had
issues?
that I've discussed. The issues are the evidentiary issues, and specifically what I wrote here. So
Sure.
all the stuff to do with the experts themselves that the judge should have, and it's all in my statement, in the official statement from Concerned Constituents of Canada, about the evidence and about the expert evidence, and then about the pursuit of truth, fairness, and biased proceedings, the truth-seeking function of the court would have necessarily required that the evidence come to the fore, and that this is in addition to getting Adam Skelly's name wrong and the style of cause at the outset, the motion decision citation wrong back in 2021 twice, and ignored fundamental questions of law and precedents brought up in written and oral argument, and then public interest standing. Those are the main issues. There are other issues, of course, but those are the main issues. They ought to be decided on appeal. They're major issues. I don't think you can duck any of them. And of course, there will be other issues, and there will be issues that are more teased out by counsel in a way
Hmm.
that a better way than I could ever do it. That's
Yeah.
that's why you have counsel doing this. And so everyone knows, I would not be allowed to represent Adam. Like I'm flattered, but I wouldn't be able to. In a superior court, there's a bit of discretion. In the courts of appeal, there's zero discretion. The only people who are allowed in the court of appeal are self reps and lawyers. That's it. So no matter what, I'm not allowed in there. I don't want to be in there. I've been in the court of appeal once when I sued the city and I lost, but it was a good experience. And then in the Saskatchewan Court of Appeal, I wasn't allowed to appear there, but I wrote all the submissions, and a very good lawyer argued it and lost as well. So my two showings or partial showings in the Court of Appeal were not they did not result in a victory, but you live, you learn, and they had to be tried.
Hmm.
Yeah.
Well, it's important work to run an organization like the one that you've put together, and to try and raise funds. Lawyers are an esteemed profession. They do good work. It's not easy work. It's high stress work, and so putting the money towards the defense is really important. Um, so thank you for that work.
Thank you.
Paul, what happened to you?
You must be here somewhere. I don't think we could continue this if Paul who's the host is not here.
I don't know. I think I think sometimes he can drop out too, and it keeps going.
We're
So
here. Yeah.
yeah, I don't know. He may have lost his connection as well.
We're
So
really weird, and if this is some kind of
Gary,
censorship, it's not going to really work very well
Crazy.
because I'm not going to shut up. So yeah.
Yeah, it could very well be. The powers that be, they mess with this show quite a bit. And it's funny because they do it through
Seeing
my
or hearing a whole
speakers.
lot of Paul. It's very
They usually
distorted.
do it through my speakers where I can't understand anything. It's just crackling.
I can hear you,
And yeah,
but Chris cannot. I don't know if you can hear me, Paul.
yep, I hear everybody. And Chris is frozen
Yeah.
solid. But I think we did talk about what we wanted to talk about. Basically, the Adam Skelly case and the fact that there's an appeals and it's expensive, and it is an important case for um, the future of Canada, what Canada means as a country, as a political force. I know that we could do much better. Everyone I know could definitely uh, be a part of it, and I wouldn't have any concern. I wouldn't be worried. Um, I know that a lot of lawyers and judges have to be replaced. I know a lot of teachers have to be replaced. So we have to really imagine a saved country, a saved Canada would need to replace all these people. So we have to be prepared and strong and support each other. And
Well, I think it's a very challenging thing with these types of professions. These are always they're always dealing with controversial issues and um, showing really high caliber professionalism is very important. Having a really strong regulator that is concerned about protecting the profession is something that we need to do. The profession is doubting itself right now. The legal
yeah,
profession and the professions within it, they're at odds. Paralegals are struggling with access to the system on behalf of their clients, and lawyers are trying to protect the quality of the system as well. But some people see a self interest in the way that that's being handled. So, um, and then you have judges that are sort of going um, astray from the legislature. They're reinterpreting the intention of the legislator, like their legislature, in certain ways that ends up protecting the legal profession. So it's a very complex mix, regulating a profession like this, and uh, lawyers themselves understand the importance of the integrity of the system. Um, and they have a lot of questions about especially lawyers who are nearing retirement. They certainly have a lot of questions about what's happened in this time frame, where there seems to be less attention to the principles of human rights that founded this country. We were all British North Americans at one point. We revolted against uh, taxation without representation and good governance. And so Canada was always about this idea of uh, bringing rights to the human beings that live within the country. Uh, One of the key separations between the British North Americans after the Revolution was this idea that slavery is wrong. And so, we have that real culture. This is where human rights were steeped and meant to be founded. So North America has a bit of a unique story in that
yeah,
that. So how can we bring ourselves back to that core? I think that's really an important part of the movement that's going on right now. And whether it's Adam Skelly's case or Tamara Litch and Chris
yeah,
Barber's case, or you've got the ostrich farm case where you had the CFIA coming in and really taking a different approach than peer countries would have taken in that case. Really showing that the Canadian government agencies are much act with a much heavier hand, with a much more patronizing or paternalizing voice towards Canadians, which is surprising because we are the most educated population on Earth. So you would think, with such a heavy investment in the education of our population, that we would also be giving people more power to determine their own future.
yeah. Well, they did take the Lord's Prayer out of school and replace it with the five pillars of Islam without parental consent. So
I'm
this
not
is
sure where
now,
they did that.
yeah, they're teaching that in school. They're giving prayer rugs. So they are harmonizing two cultures together without any uh, foreknowledge of the what will it do to the population and the culture itself. Um, Replacement theory is going to turn this country into an Islamic state, and it's showing by the education, by removing the Lord's Prayer and teaching the five pillars of Islam.
Well, so with all those sorts of concerns to the side, we certainly do see this idea of sort of neo residential school behavior where parents don't know what's best for their children, right? And that the government seems to want to step in to their children's upbringing and have this sort of we know best approach to parenting while also not taking any responsibility for parenting
Mm-hmm.
children. So that's a concern as well. But I think what we're talking about overall, whether it's one action or another, we're seeing this kind of heavy-handed approach of the Canadian government in saying that we know best to a highly educated population of people who possess inalienable rights and are unable to access them because of a legal system that has become an obstacle to democracy.
Yeah, well, Toronto is going to
I
have
don't know
a
much
month.
time. I don't.
Yep.
Oh, Chris, you're coming back in. Yeah, I don't know if you've been trying to talk, but we haven't been hearing you. So I'm going to drop out and let
Okay,
Chris
brother.
finish his
Sure.
show.
Thanks for joining us.
Yeah, thank you.
My
The
good friend Jeff
connection is
Laux,
so bad. Yeah.
How do
just
I?
back from his
Thanks, Jeff.
vacation.
You'll see this, and it says
All
leave
right.
in the upper right corner. There you go. Yeah. So I don't think anything will improve, but hopefully we can at least kind of
Mhm.
play us out as in that famous Bill O'Reilly video. Let's play us out. Yeah.
I'll write it. What does this mean? Play us out.
We're,
Yeah, I can never
we're
forget
doing
that.
it. We're doing
And
it.
then trying to take it
We're
seriously.
doing it live. We're
We're
doing
doing
it
it live.
We're doing it. We're doing it live.
We're doing it live.
Yeah.
Yeah, and I wasn't
Okay,
kidding
so
about this
I don't know.
five pillars of
I don't even know how
Islam.
much I could say. It says connection lost.
Ontario schools.
Reconnecting.
Oh, Ontario
Yeah.
schools promote Islamic agenda in
Yeah.
name of equity. Parents
Yeah.
object
We
as
already
group
know
with
what the
ties
plan
to
is.
Muslim Brotherhood.
Yeah.
Yeah,
Yeah.
we sure
No,
do.
we know what the plan is. Yeah.
And you'll hear it on the truth table. It's okay. We go off rails sometimes here,
Yeah.
but I mean it's never dull. I mean
Yeah.
you have so much information and perspective to add to whatever might be the next topic.
You're right.
And that's why I appreciate you as a guest because I feel a little smarter every time.
Thank you.
Because a lot of people just don't understand how the courts work, you know, and it's good
And
for them to be informed.
people should know. I would still say for the vast majority of people, um, and I would probably counsel almost everyone to get a good lawyer you could work with. But what my value is you can at least talk to the lawyer. You can converse. You can develop a legal strategy as opposed to just telling the lawyer, well, just get me my day in court. It's like telling a contractor to go, well, I want to
Just build a
renovate
house.
all this stuff, but you choose the paint and you choose the tiles and you
Yeah.
choose you would never do that, but people do that all the time with lawyers. So the problem with lawyers is you don't know how to communicate with a lawyer. You don't know what the aim is. You don't know any legal concepts. You don't know anything. Same thing with doctors. You should know what's going on so you can communicate with doctors and lawyers, right?
With
So
lawyers,
yeah,
people feel robbed right from the start. It's like, hundreds and hundreds of dollars for 1 hour. It's like, I'm not going to be able to cover everything in an hour.
it
So what
depends.
they
Yeah,
charge
yeah.
is kind of offensive just for their time. But you're
Uh,
right. You need to
yeah.
establish a relationship.
The relationship, and you have to be able to communicate with whoever your service provider is.
Yeah.
So if you can't communicate with your service provider, you're going to end up, there's going to be a gap in terms of what your understanding is and the service provided to you. You won't even know you're not being provided a good service. You won't even
Mhm.
know. Hopefully, because I'm talking, people will not only know they're being provided a good service, but will appreciate the service more. And of course, if they're not being provided a good service, they'll know that and get another lawyer. But and then maybe they can self-represent for part of it. But ultimately, um, it's like Shelly Joe, who I met through you. Same thing there. Like she uh, really needs a lawyer because there are too many complex procedural issues that
Mhm.
she does not want to undertake, and things that would require a lot of legal skill, like examination for discovery requires legal skill. You're not going to know how to undertake it. I don't know how to. I can tell you. I know a lot of things that I've learned in terms of hearing an application, a motion in the Court of Appeal as well, in a an appeal and all sorts of stuff like that, and in small claim stuff. But I never undertaken an action in Superior Court, so I don't really know anything about that. I don't know about all the procedural stuff and how to conduct an examination for discovery. I can conduct a cross examination just fine, but an examination for discovery, I don't know. And so this is procedural stuff. I could probably learn how to do that, but I
Sure.
can't help her. And so what she's going to need is competent counsel to question the other side, to get the actual facts before the
Yep.
court.
Yep.
And then what are your bounds? What are you like? What are you bounded by? Your boundaries. What can you say and what can you not say? How do you conduct that properly? I don't know that, and I could probably find out, but then it's still a first time out, and she would have to do it. So I would tell people, if you have some kind of quasi criminal charge like a ticket, and it could be $5,000 or whatever, you could potentially represent yourself. But if you lose, you're going to have to undertake the appeal, and everyone caved on appeal, everyone. So I knew
Mhm.
the appellant through a friend, and when she told me she actually already argued it and lost, I said, "Well, you're gonna appeal it?" Yep. So I said, "Well," she's like, "Can you help me out?" I said, "I can't help you out unless I see the transcripts." So once I saw the transcripts, I said, "I can represent you." Oh, hopefully they'll allow me to, but I know you'll win this case because you managed to say the right stuff in court, barely. If she didn't say this, there were other people who didn't have any evidence sworn in court, and those cases are an automatic loss. If you go into court on a rights-based issue, whether it's charter or Bill of Rights, provincial Bill of Rights, federal Bill of Rights, whatever, and you go in there and you argue it, you don't have any evidence before the court, no sworn evidence. You need an affidavit, really, but you have to have sworn evidence before the court to say that your rights were totally violated. If you don't have
Mhm.
that, you will get obliterated on any type of appeal because you have to have an evidentiary record to win in the initial court, let alone on appeal. And I've seen this,
Mhm.
and they'll use it. The judges will use it against that person who doesn't know any better, and then they'll get a precedent, and then they'll use it against anyone else later on. There was a case in Saskatchewan which was used against us regarding, when I say us, in another Saskatchewan case which went to the Court of Appeal. It was used there because they said that it's not Bill of Rights argument is not valid in Saskatchewan if it's just made on an absolute basis. There's no such thing as absolute rights. You need to provide evidence that your rights were violated, and you need to establish in the common law that your rights were violated. So there's a legal basis and there's an evidentiary basis. If you don't do both, you're cooked. So there are a lot of people who I've seen who've gone to court who don't know this, and that's a
Mhm.
huge problem. And there are a lot of people who try to counsel other people, and they don't even know what they're doing themselves. And they've blown stuff, like with they have an affidavit and it doesn't say anything. It doesn't. I'm blown away truly when I've seen this. There's an application or some sort of piece of paper challenging the validity of law and saying it's Canadian Bill of Rights or whatever. Someone's rights are violated, and then I'm like, where's your accompanying affidavit? And either don't have one, as I said, which is fatal, or they have one. It doesn't even say that their rights are violated. It doesn't say, oh yes, my right to freedom of expression and things like freedom of peaceable assembly in the Bill of Rights or whatever. Like, it's not in there. It's just simply not in the affidavit. And I'm like, how could you not have that in? It just blows me away. So this is why I've done the work. I've done way more work than anyone would do. I've done on the Canadian Bill of Rights alone and the provincial bills of rights. I've done at least 6 hours worth of work on that question alone. That's it. At least like 60 plus hours. Okay. No one's done that type of work. I've done it. I've looked at all the case law, all the provinces, federally, everything. And I know it. And then I know, and I've read through 400 cases in general, like all the cases that are read. It's probably exceeded 400 by now. No one reads through that many cases, not even lawyers. So you have to read through them. And they don't want to read through them. They don't want to learn the rules of evidence, the rules of civil procedure, the rules of criminal procedure, or the provincial offenses rules. They don't want to know the case law. They don't want to know what the subordinate legislation. They don't want to learn doctrines of law. They don't want to know it. They're not interested. And if you don't want to put the time in, you're going to lose. And especially if it's a political case, like anything COVID related is going to be highly politicized. You're going to have to do 10 times more work than everyone else to win. I won 2 cases, right? And I didn't win them alone, but the Fernando appeal, that was substantially me. She said the right stuff originally in court, and that enabled me to win. And in Colin McDonald, he had a bunch of submissions, but I wrote all of his closing stuff and submitted something like, was it 1,300 pages of authorities? I submitted a lot, and I would say that's why he won. And who he won in at that day, the actual day, which never is totally unheard of. Never happens. No matter what, never happens. It happens.
The judge might have just peeked at your stuff and went, "No way, I ain't dealing with this."
I think that's what happened. I think that's what happened because the judge always says, "I reserve my decision." There's a lot of materials. Like it's a double appeal, so there's 2 sets of submissions for both cases. So basically, there's one set from Cullen, another set from Cullen, one set from the Crown, another set from the Crown. We're talking about 4 submissions. And on top of that, then there's me, who comes in at the last minute with the reply factum and a book of authorities. And so looking at all that, he said, well, I see this just land at the last second here. And of course, the Crown Counsel went completely silent when being served these documents. Before, very happy to acknowledge receipt of every single thing sent to him. But when my stuff was served, completely disappeared off the face of the earth. And then, of course, the actual day of, I wasn't allowed to speak and Cullen wasn't allowed to speak. And then, of course, the decision wasn't published either. He just handed Cullen a massive win in court, but that decision was never released. And frankly, it's a garbage decision. There's 32 paragraphs. 30 of the 32 paragraphs agree with the government on everything. The last 2 paragraphs said, but because it was not, it was something that was not, it was evolving. Everything with COVID was evolving. You couldn't establish the requisite mens rea, the guilty mind, beyond a reasonable doubt, to convict him, to sustain a conviction. That was the get out of jail free card there. But he didn't acknowledge any of my arguments, even though my arguments were total slam dunk. And anyway, so we won these cases, and then there's Adam's case, and there's other cases that I've been involved with which have not won. So we're just trying to get the Saskatchewan stuff is done. Adam's stuff is very far from done, and then there's other cases involving suing the police, which I've been involved in as well. Which is COVID-related stuff involving protesting. So
I left a link to your site. The site looks great.
It is so good. This is so good. Oh, I cannot tell you how much I appreciate the people who worked on this. You have no idea. I mean, I know people like, oh, it's just a website. Big deal. Our website was barely functional for over 3 years. And there's nothing we could do about it. I kept on asking people to help us. No one would help us. And people tried, but they're like, it was like tangled, like it was a Gordian knot, like it was just you couldn't undo it. It was such a mess. And I literally had the web designer came in later, but I had a friend who for months said he would help, finally came in. All the problems he had, and we moved the site, and then there were all sorts of other problems. Finally got the designer, and he had all sorts of problems. Finally figured this out. It took like, I would say, 3 months to figure this stuff out, and after 3 years of nonsense. So we have a world-class website now,
Yeah.
and everything it's easy to update. And I didn't do any updates for like, usually for sometimes over a year at a time. I just didn't do them because why would I do them? It was so difficult to get anything to show up on the site. Like you would
Yeah.
make the update, no one would see it. Now everything shows up perfectly. Everything looks so nice, and then all the donation stuff is there, and then we can,
Yep.
and then all the court documents, and it's just so nice. So I really this is to Zen and Luvius. I really appreciate everything you've done, because without both of them working in concert, there's no way. And we accept Bitcoin, we accept Monero. There's credit and debit
E-transfer.
there. There's Give, Send, Go. There's every possible way. And then of course, if someone wants to drop off cash, you can do it to the lawyer directly, or you could do it through one of us. But ultimately, it will have to be done. It'll have to be, the cash will be transferred somehow, but it will be whoever's identity. Especially, if you want to be truly anonymous, use a de-Googled phone and use Monero or de-Googled tablet or whatever.
I would love
do
it if
that.
someone
Yeah.
with a big bag of money would just give it to you for everything
It's worth it. Like, people have no idea. People pay every day for stuff that they take for granted. They
Yeah.
pay they pay their taxes, is one thing, which is not good, but it's the law. And you can
Yeah.
say, I don't want to pay it. See what happens when you say, I'm not paying it, or I'm not going to pay my property taxes. I
think
know
he's
someone
doing.
I
Isn't
know
he?
people who've done that. They got locked out of their homes. So literally,
Wow.
it's
Didn't they
that's
say
where
they're
the
gonna?
rubber meets the road. Yeah.
Isn't he going to just do people's taxes now this year? That's what I heard.
Oh, yeah, that's for people who,
Poor people
yeah,
like
and
everybody.
listen, there's a cottage industry of like accountants who go to be literally people in the street, and like homeless basically, and then
Mm.
they go, I'll do your taxes for you for however many years that you haven't done them, and I'll do it. Don't worry, you don't have to do anything. I'm just going to take like 40 or 50% of what you get back. They'll
God.
do that and so they will get money. They will
Yeah.
just like lawyers. They'll go, we'll take your case on contingency, like for free, and on spec, and we think you'll win. But you won't pay anything unless you win. Well, with the tax refund, you win, right? You will get something back. It could be a substantial amount over 10 years or whatever, and then the accountant will take half of it. That's a pretty good deal, right? And but a lot of people, understandably, they don't even have like an address. And of course, the accountants can deal with that sort of stuff. But it is done. I know a chartered accountant who was doing that like 25 years ago, because I knew people who worked for him. So anyway, with respect to taxation, we pay for that whether we like it or not. There's a lot of stuff we pay for, obviously necessities of life, food and energy, but there's a lot of other stuff we pay for that are things that are nice to have. There are a lot of things that are nice to
Yeah.
have, right? But what's a thing that's nice to have also? Well, how about our rights? And people are not interested in paying for that. People don't see it that way. They don't see it that there's 15 million people in Ontario. There's like 40, probably up to 42 million people in Canada now. And people haven't gone, out of all those amount of people, if we got a few pennies from, like, let's say 10% of the population, we would be able to fund all this, no problem. And it is worth it, because we are going to bat for you in a way that you could not go to bat for yourself, because you
Right.
have to have standing.
Yep.
If you don't have standing, then you can't be heard in court. So literally, Adam is the only person who has standing, and to actually invoke public interest standing as well. But he's the only one. There's everyone else. You can't sue because it's more than 2 years after the fact, and you can't do anything with respect to bringing an application to challenge laws that disappeared literally 4 years ago. These
Right.
laws went off the books 4 years ago. You
Mm.
can't challenge laws that no longer exist. So this is the problem. So it is worth it for all of our rights, especially if the politicians are ignoring you, right? The politicians, we know how it works, first past the post. Politicians are ignoring us in Bill C2, C8, C9, C15, C16,
Yep.
C22. They're ignoring us. These bills are the most dangerous proposed pieces of legislation in Canadian history. And so Bill C9 has not become law yet, but it's passed the House of Commons. So now it's in the Senate. Will it pass the Senate? Usually it was rubber stamped in the past. Maybe it'll be rubber stamped now. And it will be rammed through. If that's the case, I don't know. But if it is rammed through, then guess what? You can't say things online that is considered hate speech. And hate speech
Yep.
is whatever the government hates. Let's be clear.
Exactly.
So what can they do to you? They can go after comments you made in the past 10 years ago. They can go after comments you haven't made yet in the future. They can say it's like pre-crime,
Yeah.
like we think that you were about to make comments like that. And then about comments that you just made, right? Like they did in Britain. They've arrested thousands of people in Britain. Of course,
Yes.
not arresting the hardcore criminals, the groomers and all that,
Nope.
the people
Just the
who
posters, the
the
memes.
violent criminals, right? They're not going after them. They're going after people who are post deadly things against the government. And listen, it is a crime, and it has long been a crime to utter threats online.
Yeah.
There was actually, I got to say this. There was one woman who uttered a bunch of threats online, and they presented it as if sort of the end of the world, because police came to her door and they said, if you say this again, we're going to arrest you. People got very upset at that, but they left out the fact that she did make threats against, like, actual violent threats against the prime minister, and she didn't get arrested. In the U.S., she would have been locked up in seconds. So yeah, you cannot, irrespective
Where
of
we're heading.
this nonsense that we are headed
Yeah.
fast to hell in a
But
handbasket.
this is happening all over the world.
All over the world,
Australia.
especially in the British common law
Yes.
jurisdictions. They went after us hard during COVID.
Yep.
Why? Because British common law is what made both democracy and capitalism possible. If you don't have British common law, you don't have the capitalist system. You don't have contract law. Basic contract law cannot be enforced generally without British common law. Yes, there's other types of legal systems and there's contracts, but British common law is the gold standard. And it has been for centuries. So the capitalist system can't exist without contracts. It can't exist without the civil legal system and the British common law civil legal system.
Mm.
And then there's the democracy as we know it is based upon British common law. Like in Canada, we don't have constitutional rights with respect to property rights. That's not in the Constitution. It does say in section 92(13) provincially that the civil rights, which property rights essentially, are cared for by the province, but they could be removed because they're not in the Constitution expressly, in the Charter or in the Constitution itself, 1867. It's not in there. It's not in there in New Zealand. It's not in there in Britain. It's not in there in Australia. It is in there in the U.S. in the 5th and 14th Amendments. But in the U.S., they don't have a constitutional remedy if the government breaks the law. If the government violates the constitutional law, there is no remedy in the Constitution. The remedy is in the Ku Klux Klan Act of 1871. So, and that's called that's one of the it's called Section 1983. That's what they use. In Canada, we're the only country on the planet which has not only this stuff in a charter, which is constitutional law, supreme law, it also has remedies in the charter itself, Section 24 and 52. No one else has that. So people are very quick to bash the charter, and the charter needs an overhaul. Our Constitution needs an overhaul. We need to get rid of Section 1. Section 33 is okay because it allows our elected representatives. And you've seen how they've acted, which is atrocious as well.
Yeah.
But at least you have all these different people who are elected, not appointed,
Yeah.
and they're subject to not being elected again. So assuming you don't have a complete socialist population, which right now over 50% of Canada is dyed-in-the-wool socialist, literally socialist, and that's a whole other problem. But assuming they invoked the notwithstanding clause, section 33 of the charter, that they could potentially be voted out if they invoke it. But if you have section 1, it means any judge, one person, could overturn the charter. And we saw that so many times. And so I don't think a judge should be able to do that. I think that the
Yeah.
legislature should be able to do that. I think I've lost, like, very clearly. I mean, if judges won't look at evidence and things like that, it shouldn't be put in a single judge's hands. Not anymore. It's like if you've ever seen Crimson Tide with Denzel Washington and Gene Hackman, fantastic movie. He literally won, and this was true back then in those days, in the 80s. One sub-commander had the power to start a nuclear war. They don't have that power anymore, but they did, and that was what that whole movie was about.
Wow.
And so one judge could cancel the charter for everyone, and that's what happened again and again. And the only way we can win our charter rights back with respect to public health doctrine is with the Skelly case. It's the only way, because we know how things have gone. The common law has said the government can do whatever the hell it wants with respect to public health, and that they can rewrite. Now, that's a whole other story. If they rewrite the statutes, they rewrite the EMCPA, or the ROA is still there. They could write another law. They could rewrite the ROA. It's still there. So ultimately, the legislature does have the final say, and they are elected. And we all know about the Dominion voting machines and everything else. And the first
Yep.
past the post system is guaranteed to create a Coca-Cola and Pepsi democracy. And I'll put in TAB as well. If you remember the 80s,
Yep.
sugar-free drink TAB, which is the NDP. But essentially, it's a Coca-Cola and Pepsi democracy. Every democracy is Coca-Cola and Pepsi democracy, because first past the post guarantees that. The only difference to that would be the Israeli democracy, which is everyone has a political party. There's dozens of political parties, and then the same people, of course, run everything for decades.
Yeah.
So that's not desirable either. I think there are a lot of people who have issues there. So either way, this is not working. We're not going to vote our way out of this, right? As with socialism, you can vote your way into socialism. You can only shoot your way out. Communism is imposed by force, and you can't shoot your way out of communism, because they'll kill you. They take all the guns, and then they'll kill you and your family and your friends. And everything. So it's socialism, not communism, that you can shoot your way out of. I don't know what's going to happen in this country. I'm telling you, this is went full Soviet with this with the Skelly case, where they're disappearing the evidence. This is Yuri Bezmenov 101, the 4 stages of ideological subversion, where you cannot, if you're fully demoralized, you cannot tell the difference between fact and fiction. You won't even look at the evidence. I don't think that's what happened here, but I can't tell you what happened. I don't know.
No.
And I don't. I just want to say it was fundamentally unfair and unjust. Truth seeking function of the court was utterly destroyed. And these are good ways to bring an appeal to the Court of Appeal, and even to the Supreme Court later. So I think you just can't give up. That's the key.
What about? What if Bill C9 gets royal assent before the appeal?
Doesn't matter. Appeal has nothing to do. We did everything right. So and I know people are weary about giving money to the case, because they're like, well, it'll be tracked. It's e-transfer. It'll be the give, send, go, or it will be whatever, credit card, debit, etc. It'll be tracked. And then I tell people, the difference between our case and the convoy is the convoy was illegal for quite a while. It was completely illegal by virtue of the emergencies orders. It was illegal under the EMCPA. It was illegal under the Emergencies Act. So 2 separate emergency statutes, federal and provincial. It was illegal until eventually the federal court struck it down. But it took nearly 2 years to strike it down. So with our case, everything was always not with respect to what Adam did, and he was criminally charged, but everything else was done legally. With respect to the legal challenge, everything couldn't be done better in terms of being done legally. So if you give money to a legal challenge, nothing can be done by the government to say you can't give money to that challenge. No. If people dropped off or decided to, send us $100,000 equivalent in Monero, there's nothing the government could do about that. We would have to account for it properly under the accounting rules of the Canada Not-for-Profit Corporations Act. But aside from that, we're following the law, and anyone else who gives us money, as long as we follow the law, and if
Yeah,
we have to
absolutely.
disclose names, we can do that. But ultimately, they can't do anything to you because you follow the law. You've done it in the most civil possible way, and that's why we're trying this. We don't want. I think the courts and I think politicians would agree that we don't want to descend into anarchy and barbarism. And personally,
No.
I think, I agree with Gandhi and Jesus Christ himself, that organized anarchies are the way to go. Decentralized anarchies are the way to go, meaning we're self-governance. But it has to be done in a proper way where people's rights are respected. And that could potentially be done without government, but with governance. That's because of what we have today compared to when responsible government first came into place to replace monarchies. So we have the modern day democracy was born a few hundred years ago in this responsible government and British common law and everything else. But it's become very tiresome. It's become a way it's being seized by the elite classes, and everyone knows this. So it can't continue. I mean, it's nearly 39 trillion. I thought it was 37 trillion in the US, 39 trillion. Canada is even worse off with respect to our overall debt per head in Canada,
Yeah.
right? So,
Yep.
and then it's not going to last. It cannot last. So the Great Reset's going to happen no matter what. The only question is our response to the Great Reset. We should say hell no to any government. And there will be a lot of people who beg for government. If half the population or a substantial portion says screw you, hell no, then we won't have it. And we will get to a point where the debts cannot be paid, both the government debts, bank debts, personal debts. We're nearly there. Canada is in the top 3 of all of the highest debt metrics on the face of the planet, higher than everywhere. So
I can see how we're going to own nothing, but can you tell me how they can guarantee happiness? How are we happy?
Yeah, no, it's
2030.
it's total misery. Like that's what I guess it was Churchill who said that. It's misery for all. Like socialism, communism is misery.
Misery for all.
Or you could say that some
Is
animals
it drug induced?
all
Maybe?
animals are what?
Could it possibly be a drug inducement? Like they could like spray Valium from
Yeah, we
plane?
know it's all been done, Paul. We know. Brave New World we're
Yeah.
closer to Brave New World in 1984 because
Yeah,
Brave
sir.
New World is all the shiny shit,
Yep.
all the mind-numbing substances.
AI.
At the end of 1984, Winston cries gin-soaked tears, and it's the fake clove, and all that, and he because he's so thoroughly demoralized, and then he realizes he loved Big Brother. That's the whole demoralizing ending
Yep.
of that
Yep.
book. But we're more of Brave New World. Brave New World is about making people feel good, right? People giving them free shit, right, and giving them there's the free gin in 1984, but there's a lot more stuff to do with drugs and just the bread and circuses and all of that. At
Mhm.
the end of the day, and they are trying for this totalitarian welfare state and warfare state. They're both the
Yeah.
same. They're
Yep.
both trying for that. And yes, if they succeed, we could have that type of totalitarian state for decades. It could last for 72 years, right? Like the communist system. Look at China; it's still around after 72 years. In
Yeah.
1949, the Soviet system ended 72 years later. And what will happen if these systems are imposed and somehow people decide to go along with it? I don't see that happening, but let's say that happens. And we don't need too many people to say hell no before the government collapses. We don't. And to do and to be clear, like I'm saying hell no. I'm not saying we need some kind of huge revolt, like any type of physical revolt. All people need to do is withdraw their consent. It's over before nightfall. 10% of the people out of this country, for over 4 million people, say hell no. And these are people who show up. They can't just say from behind a screen, hell no. They have to show up in the streets. They have to show up and say, we're not doing this anymore. We're not paying anything. We're not putting the nooses around our necks. We're not enabling law enforcement to enforce unjust laws. We're not doing it anymore. Sorry. That's all you need, and it's over. And that has happened in other countries. It happened. Was it in? I don't. I think it was in Sri Lanka. I
There's a
think it
lot
happened there.
happening
Yeah.
around
Yeah.
the world. There's a lot happening, a lot of revolts, and
Yeah.
mass on a massive scale.
Yeah.
I'm losing my voice, but I hope that you'll come back after the Skelly case. Uh, if C9 gets royal assent,
Yeah.
it probably will be called the disinformation table.
Yeah.
But
I'm.
I hope you
Yeah.
will
I will
come back.
know the law very well with respect to C9, so I will know how to get around it in terms
Yeah,
of comply with it, but be able to say what I want to say. And I'm
yeah.
very careful. Like, I would never ever threaten any official. And there are people who've done this. They've sent threatening letters to officials, to judges, and things like, no, you don't need to do that. I haven't
No.
even slagged this judge. I've said that she's made all these errors, but I haven't slagged her. I don't want to
Hmm.
make it about slagging a judge. I
Yep.
want to make it
Yep.
about legal principles,
Professionalism.
which
Yes.
have been around for centuries, which you have to
Yes.
follow.
Yep.
That is, it's fundamental. Everyone should know this. Everyone should say, if judges can't do their jobs, they should recuse themselves.
They
If
should.
courts don't want to weigh the evidence, then they shouldn't exist in that perspective. They shouldn't pretend that they're going to weigh the
Yes.
evidence and not. They shouldn't
Absolutely.
pretend. And so the same thing goes with the democracy in general. If the democracy is supposed to protect life, liberty, and property, and they end up destroying life, liberty, and property, and they just want to regulate every facet of our lives, which is not what government is there to do.
Hmm.
But apparently, since the early 80s, it has been there to do that, to displace hundreds of years of democratic rule with regulatory rule. To basically say life, liberty, property, that takes a back seat to regulations, to basically regulating your conduct. That's what we have today. So
Yeah.
they basically said, we can destroy your life, liberty, and property because we need to regulate your behavior with respect to public health.
Hmm.
And that is literally when you destroy life, liberty, and property, which is why government exists. Our modern system of government exists to protect life, liberty, and property. If you
Yep.
destroy that, they've ceded their legitimacy to govern. And I can say that very safely, that is how our system works. And if they've ceded their legitimacy to govern, it is up to everyone to defy the government. And how do they defy it? Simply say no. Just say no. Like do as Nancy Reagan and just say no.
On that
That's it.
note, thank you so much, Chris.
Thank you.
I
Thank
always
you, Paul.
appreciate your time, and I value you as a friend and as a human being. And after the Skelly case, I will hope to have you back and discuss hopefully a win. Or if you want to do a fundraising drive show, I'm willing to do that as well. I am leaving Facebook, but I'm still be on
Yeah.
all the other platforms. And
Yep.
so thank you for your time, and it
Thank
was
you.
always a pleasure. And thank you at home for joining us on the Truth Table, third episode today. Uh, no voice left.
Yeah, a lot.
We'll see you tomorrow at 2
Thank
p.m. with
you.
Tyler Bulliard. We'll be here tomorrow to talk about the family court, family children's services. Tomorrow at 2 p.m. See you then. Thank you, Chris. And thank you at home. It's always a pleasure doing this for you at the Truth Table, being a host. And I will see you tomorrow.